Tansy, welcome to the 20th Annual Speaker Series presented by the Indigenous Law Students Association at the University of Alberta Faculty of Law. Thank you all for coming. My name is Justin Helsvold. I am a second-year Métis law student and chair of the Speaker Series Committee. First, I'd like to respectfully acknowledge that this meet is being hosted on Treaty 6 territory, a traditional gathering place for diverse Indigenous peoples, including the Cree, Blackfoot, Métis, Nakota Sioux, Iroquois, Dene, Ojibwe, Saulteaux, Anishinaabe, Inuit, and many others whose histories, languages, and cultures continue to influence our vibrant community. We would like to thank all members of Treaty 6 for attending, as well as the elders who are with us today. And finally, we would like to thank the Faculty of Law, the Alberta Law Foundation, and Rising Youth for their support. Each year, we spend 5 days to talk about Indigenous legal issues that affect our peoples here in Canada. This year's topic is Indigenous perspectives on the last year. It has been exactly a year since this faculty was all together. In the meantime, Canada's Indigenous community has shown inspiring resilience and legal acumen in the face of incredible challenges. Challenges to our rights, health, water, land, and livelihoods. You've seen it in the news. This is our side of the story. Here with us today is Dean Barbara Billingsley, who has a few words to share with us. Ladies and gentlemen, Dean Billingsley.
Thank you, Justin. Good afternoon, everyone. As you know, my name is Barb Billingsley. As Dean of the Faculty of Law at the University of Alberta, it's my pleasure to welcome you all on behalf of the Faculty of Law to the 2021 Indigenous Law Students Association Speaker Series. I want to begin by thanking the Indigenous Law Students Association for once again organizing this important annual event. Our faculty is fortunate to have such a dedicated group of students who are focused on supporting self-identified Indigenous students and those who have a strong interest in Indigenous justice issues. I've reviewed this week's program, and I'm sure you will agree that the Indigenous Law Students Association has once again done an outstanding job of putting together a compelling roster of speakers on a wide range of highly topical issues. I also want to thank the Alberta Law Foundation for generously supporting the speaker series. The Alberta Law Foundation has become an important partner in making this annual event a reality. I'm also very grateful to the Indigenous Law Students Association for inviting me to speak to you today. I know that you are anxious to hear from today's speaker, Leroy Little Bear, so I will be brief. As many of you know, I assumed the role of Dean of the Faculty of Law just last July, which is to say that I have not been Dean for very long. But I've been a member of this faculty for nearly 20 years, and some years before that, I was a student at the faculty. Over these many years, I have witnessed tremendous growth in our faculty's support of Indigenous law students and Indigenous legal studies. Back when I was a law student, some 30 years ago, Catherine Bell was the only professor at the University of Alberta teaching one course in what was then known as Aboriginal law. The idea of creating an Indigenous law program to open law as a viable career path for Indigenous students was just in its infancy. Since those days, much has changed. For example, I'm proud to say that our faculty currently has 5 professors who list Indigenous and Aboriginal law as primary areas of academic focus. Our Foundations of Law class, which is mandatory for first-year students, exposes our students to the history of Canada's Indigenous people as part of our legal history and includes experiential learning opportunities such as the Caris blanket exercise. And beginning next fall, incoming law students will also be required to take a course incorporating Indigenous law content in their second or third year of studies. The Faculty of Law is also now home to the Wakotuan Law and Governance Lodge, a project created through the partnership of the Faculty of Law and the Faculty of Native Studies to support Indigenous law and governance through research led by the Indigenous community. I offer these as just some of the examples and illustrations of ways that our faculty is demonstrating its commitment to ensuring that all of our students enter the legal profession with knowledge of Indigenous laws and legal traditions and the application of Canadian law to Indigenous peoples, and to ensuring that our Indigenous students have the opportunity to thrive as law students and ultimately as members of the legal profession. The faculty's support of the Indigenous Law Students Association and of this lecture series is an important part of that commitment. Thank you, and I hope you enjoy this week's events.
Thank you. The presentation will be about 45 minutes with 10 minutes at the end for questions. Please use the Q&A function at the bottom of your screen to ask any questions you may have. The chat function is disabled. Your questions will not be visible unless they're answered in the Q&A. This session is being recorded. All participants acknowledge that photos and videos will be taken of the event. We are joined by Sarah Johnson, a member of the series committee, to introduce our speaker and handle questions. Sarah?
Thank you, Justin. As Justin said, my name is Sarah Johnson, and I am a first-year Métis Law student here at the U of A. Thank you all for coming and joining us for our first day of the ILSA Speaker Series. To kick off this year's event, I am very honored to introduce our first speaker, Leroy Little Bear. Leroy Little Bear is a Blackfoot researcher, professor, and founding member of Canada's First Native Studies Department. Little Bear is a recognized leader and advocate for Indigenous education, rights, self-governance, language, culture, and has won many awards, including the Officer of the Order of Canada and the Alberta Order of Excellence. Leroy Little Bear's dedication to education, leadership, community building, and advocacy has led to a United Nations declaration, changed the Constitution of Canada, and influenced the lives of thousands of students. His influence continues as he teaches courses in law, philosophy, economic development at the University of Lethbridge. Through his work, Leroy Little Bear has given Canadians a shining example of scholarship, leadership, collaboration, and advocacy. Now, without further ado, we will turn it over to Mr. Leroy Little Bear.
Thank you very much, Sarah. I am very honored to have been invited to share some thoughts with you on the topic of sovereignty today, to kick off some of this series of talks. And I want to congratulate U of A, the Indigenous Law Students Association, the law school, for the wonderful work that you're doing in the area of law. So I'm very, very honored to be able to share some thoughts with you. So to start off on this very important issue about sovereignty, I would like to share a PowerPoint presentation that I've prepared for this occasion. So let's get right into it. Yeah. When we're talking about sovereignty, some people don't always understand what it's all about. Most people simply take it for granted that it exists, but don't have a very deep understanding what it's all about. So let's see if we can get a good understanding of what sovereignty is about before we really get into the notion about sovereignty and First Nations people. So let's answer the question, what is sovereignty? Well, for me, sovereignty is when a society, through a collective agreement, if you want to call it a culture, is brought about by its relationship to the total environment. And this total environment includes the cosmos, plants, animals, air, water, and so on. And that society claims a territory for its exclusive use. In other words, that society starts to become what I would refer to as self-contained. Now, when a society becomes self-contained or sovereign in this case, it excludes other societies from interfering in its territory and internal affairs, unless, of course, it gives consent to that other society or societies. Now, however, no society is 100% sovereign. As soon as a partnership, for whatever purpose, is engaged in, one becomes a little less sovereign. I like to use the notion of marriage as an example. When you get married, for instance, you give up some of your personal sovereignty. In other words, when you're single, hey, you have a whole lot more freedom. But when you get married, hey, you have to take the other person, your partner, into consideration. But so to have sovereignty, you have to have an internal agreement of the members of the society. In other words, that's where culture, that's what I mean by a collective agreement. You have to have an internal agreement of the members of the society that say, you know, this is how we're going to live. Otherwise, all you'll have is, you know, a bunch of individuals, you know. All you'll have is a bunch of individuals all doing their own thing, say. So that's where laws, customs, constitutions, and the like come into the picture. So, sovereignty has to be kind of like recognized. It has to be something that members of the society have to agree on. Everybody has to agree that these are the life ways, these are the rules, these are the laws that we will all adhere to, say. everybody has to agree to a particular form of government. This is what political philosophers like John Locke is talking about. In other words, we may at one time theoretically be sovereign. And when we come together as a society, we all give up a little bit of our sovereignty to this new collective entity that we call government. See? So that's how government comes in. And it takes all those little pieces to make that new entity. Now, the other aspect is that this notion of sovereignty is also a statement to outsiders. Hey, we are an entity and we're making a statement to outsiders that we have to be recognized as a separate entity. In the community of sovereigns, more or less, there's a gentleman's agreement, and in some cases, formal agreements that they will respect each other's cultures and territorial claims. When boundaries are not respected, for instance, as far as territorial claims are concerned, usually wars are the inevitable results. So let me stop and make an observation here. See, a lot of times we think that the sovereign, and in our case, the crown, which is the symbol of sovereignty in Canada, that they own the land. Sovereigns don't own land. See, they just have kind of like a claim, and all it is that other sovereigns have agreed through kind of like a gentleman's agreement, a shaking of, a handshake, that they will respect your claim to a particular territory. See, they promise, so to speak, I will recognize your territorial claim so long as you recognize my territorial claim. See, and we'll get along okay. We'll have a boundary over here. Don't interfere in my business. I won't interfere in yours. See, but at any given moment, one sovereign can decide not to pay attention to those territorial claims and cross the boundary. And that's where wars break out. And just think of, places, all over the world where that's happening. See, an example of the internal recognition of sovereignty, hey, that's when civil wars turn out. In other words, the members of the society themselves are not agreeing on how things should be run. Just think about Myanmar, it's making the news today. So just like marriage, as soon as you join the community of sovereigns through some international body, you become a little less sovereign. When you start depending on somebody else for your needs, you become a little less sovereign. So in other words, when you start depending on, in Canada, when you start depending on the United States, when the United States starts depending on somebody else, they become a little less sovereign. That's what we mean. Nobody is 100% sovereign. Now, in some cases, you may have a bargaining power. In other words, you might have oil. You might have some other natural resource that you can use as a bargaining power. But that's not quite the same as sovereignty. You may have a bargaining power, but that's not quite the same as sovereignty. So, with that kind of a background, let's look at First Nation sovereignty within the context of colonialism. When Europeans came to the Americas, First Nations were sovereign. That's a fact, okay? There's no argument about that, okay? Now, and Europeans treated them as such. And in many cases, they had no choice. They had to treat them as such. In other words, they would not have survived without the First Nations anyways. And one of the first legal recognition of First Nations sovereignty was the 1725 and later 1752 treaties with the Mi'kmaq. Those were the treaties that were the subject of the fishing rights that we saw in the news and that were the subject of the martial cases in Nova Scotia. And we have to remember that only nations can sign treaties. Somewhere in that period, there was also a treaty with the Vatican. There was a papal treaty that the Mi'kmaq had signed with the Vatican. Now, then came the Royal Proclamation of 1763. See, the Royal Proclamation was kind of like an administrative attempt to control the 13 colonies that were wanting to break away and so on. But, you know, so they put a whole bunch of governors here and there and so on. And the, you know, the crown from Great Britain was wanting to control the newly formed colonies and so on, who were having tea parties and so forth, so on. And it was in the Royal Proclamation that there was reference to the several nations or tribes of Indians with whom we are connected and who live under our protection. Here, let me explain the notion of use and protection, which is a little bit self-serving and unilateral in this proclamation. See, when you go back in the history of Great Britain, you will recall that it was made up of a whole bunch of tribal kingdoms, okay? And it was in those tribal kingdoms and so on that had battles and little wars here and there. And, you know, there was a time when, you know, you will remember from when you were going to school, you know, the song about Humpty Dumpty sat on a wall, Humpty Dumpty had a great fall, and so on. All the king's horses and all the king's men couldn't put Humpty Dumpty together again. You know, that was really a political song that was referring to those times. See, but see, the thing was, all the king's men used to come to the peasants who were the farmers and basically tell those farmers, the peasants, you know that at any time, somebody, one of the enemies, the other tribal kingdoms, can come and attack you guys. And they can destroy your crops and so on. How about if we enter into an agreement where you, the farmers, the peasants, continue to use the land as you've been doing, and we, the king's men, we will protect you, providing you give us a share of your crops. That was the payment. So there was this notion of use and protection. So if you keep that in mind and read the Royal Proclamation, and when it says those several nations or tribes of Indians with whom we are connected and who live under our protection, you begin to see where they're coming from. See, in other words, they were wanting the Indians, and they were looking at the Indians as the peasants, the farmers who were using the land, and they were the king's men that were going to protect. And that's what I mean, that particular clause in the Royal Proclamation is a little bit self-serving and unilateral on the part of the crown. Say. But nevertheless, it goes on, of course, in the Royal Proclamation that they recognize that any land that has not been surrendered to the crown remains the Indians' lands. Say. So it is recognition of the sovereignty of the tribes and those several nations and so on in the Royal Proclamation. See. And then, of course, came a succession of treaties. There was the pre-Confederation treaties around Lake Huron and Lake Superior. A little bit of background to that was, of course, there was the fur trade, okay? And the British wanted to protect the fur trade, okay? Who were the suppliers? Well, of course, the Indians were the suppliers. And they didn't want anybody to mess around with the suppliers, okay? But when the fur trade started to go downhill and so on, and valuable minerals like nickel and so on started, iron ore was discovered on the north shores of the Great Lakes. That's when the pre-Confederation treaties around Lake Huron and Lake Superior were entered into. And that's when the British thinking started to change. In the fur trade, they needed the Indians. But for those minerals, those natural resources like iron ore and so on, they wanted the Indians out of the way and put them on reserves and so on so that they can get at the natural resources. And those pre-Confederation treaties ended up being the templates for the numbered treaties. But nevertheless, they entered into treaties. And as we said earlier, only nations can enter into treaties. Sovereign nations, only sovereign nations can enter into treaties. And so as the British moved to further and further west, the numbered treaties and so on came further and further west. See. And the treaty making process is still going on. It's going on in British Columbia, so on. In other words, the sovereignty recognition is still going on today. And this all points to the ongoing recognition of First Nation sovereignty. See. Now, what have the courts been saying about First Nation sovereignty? Well, in the year of Confederation, there was a court case, Connolly v. Woolrich. What Connolly v. Woolrich was about was Connolly was a Hudson Bay employee, Hudson Bay trader, who was up in the Athabasca territory, northern Saskatchewan, northern Alberta, southern Northwest Territory. And when he was there, he ended up marrying an Indian lady. And according to the record, he was married according to Indian law. Some put it according to Indian custom. And from that marriage, he had a couple kids or 3 kids. And everybody in the community knew that they were married. After several years, Conley decided to retire. So he packed up his belongings and his family, and he moved to Montreal, back east to Montreal. Well, the way I half jokingly put it, it's he no sooner got on St. Catherine Street in Montreal, for those of you that are familiar with Montreal. He dropped his Indian wife and married a white lady in the church. But in the meantime, he had written out a will. And he must have known he was going to pass and so on. When he did pass, he had willed everything, whatever he had, to his white wife. And when he did pass, his children from his Indian wife contested the will because there was nothing in the will for them. And to make a long story short, the court said, you know, when we talk about marriages and so on, it's kind of like, if we use a modern day example, a lot of people, a lot of Canadians go down to Las Vegas to get married. Well, if it's legal in Las Vegas, that is, if the marriage is legal in Las Vegas, we'll take it as legal over here. It's known as comity. We recognize each other's law, okay? Well, at the time when they were together in Athabasca country, what was the law? And the judge basically said it was Indian law. Woolrich, his wife, and their side were arguing that Hudson Bay Company was there and the presence of white people had extinguished the Indian law. And the judge said no, because Hudson Bay Company was a chartered company. It was not a government. And therefore, it cannot displace law. And the presence of a few white people cannot displace the existing law, meaning the Indian law. So the end and be all of this was that Indian law was still in place in 1867. See, I throw in J.J. Curran. Going back, even though this was not a court case, I throw in J.J. Curran, who was the Solicitor General of Canada in a dispute with regard to the Lake Huron and Lake Superior treaties between Ontario and the federal government. And the Solicitor General of Canada at that time, J.J. Curran, said, these treaties are governed by international law, not by the domestic law. So in other words, recognition that First Nations can enter into treaties and therefore recognition of their sovereignty. Okay. So the Connolly v. Woolrich case is recognition and, very important in the sovereignty history of First Nations. First Nations have also, if you go down the history of these cases, you will find that in, cases like Simon case 1985, you will find the Supreme Court saying that Indians can have entered into these treaties. Treaties, are to be read as, as living documents, not frozen in time. You will find that the Siwi case says Indians can, have the full capacity as nations to enter into the treaties and so on. So, and the latest, of course, is, the Haida case, interpreting Section 35 of the Constitution of Canada. What is Section 35 all about? Well, it's to reconcile the sovereignty of First Nations with the presumed sovereignty, as the court put it, with the presumed sovereignty of the Crown. See? So that's what Section 35 is all about. See? So, in other words, the courts recognize that Indians are sovereign. So, Darren is all about fiduciary relationships, that the Crown has a relationship with those and that they have obligations under those cases. Simon, as we've said, are sui generis and cannot be read as frozen in time. Siwi case has First Nations have full capacity to enter into treaties. Dalgamuk, oral histories have the same legal weight as written histories. See? What more can you say? Haida case, that First Nations have, sovereignty. These are examples of court cases all pointing to the continuing recognition of First Nation sovereignty. And of course, in 2014, a number of First Nations, and now including the Musqueam's bands, have entered the Buffalo Treaty. The First Nations entered amongst themselves a treaty revolving around the buffalo, because the buffalo is such a keystone animal with regard to our culture, you know, our songs, our stories, our ceremonies revolve around that buffalo. It's not just about sustenance. It's about songs. It's about stories. It's about ceremonies. And they've all agreed through that treaty that they will all work together to restore the buffalo. And it's happening. Poundmaker just received, you know, a number of buffalo back to their reserve. Frog Lake, Meadow Creek, the Blood Tribe, and so on are all getting buffalo back because of its importance. In other words, they are implementing the Buffalo Treaty. Yeah. So First Nations today, through all these processes, are still recognized as sovereign. Their sovereignty may be reduced a bit, somewhat, through partnership, as we said at the beginning, and through legislation, but it still exists. And it's not unlike the Crown's sovereignty. It has been reduced through international trade and membership in international organizations. So First Nations are still self-contained culturally and land-wise. Aboriginal title underlies the presumptive title of the Crown. That is the most important evidence of the continuation of First Nations sovereignty today. So it exists, you know, there's just no doubt about that, you know. And sovereignty is something that's very, very foundational to all the rights that people talk about, not just for First Nations, but in fact, if you look a little bit deeper, it's very foundational to rights that Canada has. And it owes a lot to those rights because it received those rights from First Nations through treaties. Thank you very much. I'll stop there and I'll be glad to enter into a little bit of, you know, question and answer at this point. Thank you.
Thank you so much, Mr. Little Bear. We really appreciate hearing from you. We do have a couple of questions from the group here. So the first question is, can the legally recognized First Nations sovereignty in Canada be constitutionally codified? And if so, how?
It already is. It's in Section 35. It already is. It's in Section 25 and it's in Section 35 of the Constitution. It's already there. Yeah.
Okay, the next question is, if Tsuut'ina wanted to build a dam on the Elbow River on their reserve land, could anyone stop them from a legal perspective, not taking into account any provincial or federal environmental assessments?
Yes, they can. However, when it comes to being good neighbors, okay, and because of other agreements that we have in place, okay, we have in place, those agreements have to be recognized. And that's what I mean when the sovereignty is, you know, as soon as you enter into those agreements or join a partnership, see, that sovereignty is slightly reduced, you know, becomes a little bit less. You take a little bit of your sovereignty pie away, okay? And so those agreements would have to then be taken into consideration, okay? So things like water rights and so on would then have to take in place, you know. And so water rights issues of the other parties would have to then come into, you know, into consideration. Yeah.
Thank you. Another question is, I think it's interesting that sovereignty is grounded in the internal coherence and agreement of its peoples. Does this mean that Indigenous sovereignty is expressed in multiple and various ways across Canada, according to the large number of cultural centers and their levels of internal agreement and organization?
Very much so. It's the culture that is, you know, a group of people that come together, that agree and say, this is how we're going to live. These are the rules, and these are the regulations, so to speak, cultural regulations and so on. Now, in many cases, we, you know, we don't think about it, but in many cases, we're born into them, okay? Now, there used to be a practice amongst our people where if somebody did not want to live by the rules of the group, okay, they used to be, if I can use the word excommunicated, they would be exiled, and they would tell them, okay, if you don't want to live by our rules of the group, you can go live way over there by yourself, where nobody will tell you how to live, and you can live on your own, see, and live, nobody will tell you how to live. Make your own rules and so on, see. And that did happen. And every once in a while, eventually, the exiled person or family eventually will say, oh, we made a mistake, we'll come back in, okay? So, but the main thing is, that's where social values come in. Their social values, one of the roles of social values is, you know, to give rewards and so on to make people stay within the group, okay? And so you know, but there has to be some internal cohesion and so on. And language is one of them. Language plays a very important role, see, because we all speak the same language, and therefore we all have the same thought processes, okay? But if we don't have that internal cohesion, hey, everybody goes their own way. And, you know, then we start to become just a group of individuals, all doing our own thing.
Thank you. We have another question here from Danielle. She says, I speak for our children here in Southern Alberta as a past student of Calgary and Lethbridge University. I am wondering, ethically, how do we face the scrutiny of our partnership while at the same time acting in a manner respectful of our precious children and their wishes? When working with our most vulnerable population and disenfranchised friends and family who have been mistreated by colonization, what do we do when our relationships intersect?
Well, the thing is, probably the example I give is there was a book written many years ago by a guy called, his name was Daniel Cochrane. And his book was titled The Hidden Ireland. Okay. And you know that the British had colonized Ireland before they came to the Americas. Okay. And I always say they had a practice run on the Irish before they came to the Americas. Okay. And in the book, Daniel Cochrane says, we were living next door. We lived right next to each other with the British. But the way the British treated us was as though we didn't exist. Okay? We could be next to each other, but they treated us as though we didn't exist. But when I look back, it was a blessing in disguise because they didn't bother with us. It allowed us to keep our own songs, our culture, our literature and language, and so on. See, and today that culture, language, literature is in full bloom. See, well, to a large extent, you know, we've been in this colonization process. It's almost like they're trying to make us like them, see. Well, when in reality, that separate treatment is allowing us to keep our songs, our stories, our ceremonies, and so on, our language, see. And, you know, it's keeping our culture alive. So it's a, you know, on the one hand, it's a blessing in disguise, see. But on the other hand, there's that law that says equality, see, but it's not being lived up to. The law is not living up to, and it's not enforcing the law to make all these different cultures equal, because if we're going to be a society of different cultures, see, then the law should be and treat everybody alike. Otherwise, quit talking about equality, see. In other words, we should be talking about a monoculture, say. So if we're going to talk equality, let's really mean it. And let's make programs that'll make for a multicultural society.
Thank you. so it is 1 o'clock now, so I understand some people have to get to prior commitments, but we do still have a couple of more questions. Mr. Little Bear, if you're interested in answering a couple more.
Oh, no problem.
Yeah?
No problem.
Okay, we'll do a couple more here. So this question, what do you think about numbered treaty persons being offered engagement tables to open up sacred treaties in order to negotiate more jurisdictional arrangements with the Crown government? Do you welcome this process or warn against it?
The Simon case that I referred to said treaties should be read as living documents, not as frozen in time. Okay, so I don't see any problem with taking a treaty and saying, hey, let's add to the treaty, and so that just like my computer, let's update it. Okay, let's update the thing and make it more compatible with our needs for the moment, for our time and so on. That was what was meant in the Simon case. They should be taken as living documents, not frozen in time. And I always come back to the notion of and use marriage as an example. Okay, so, hey, a couple gets married, and at the beginning of the marriage, they say, okay, here's how we think we're going to run the show, okay, between man and wife and so on, who's going to go to work? Are we both going to go to work and so on, or what? But then something develops, okay, something comes along, and we may have to change our plans, see? So, hey, well, let's go with the times. We have to change our plans because something different has developed, So, and that's how I look at the treaties. So I don't see anything wrong with, it's not saying we're going to do away with the treaty. We're saying we're going to update the treaty. Yes.
Thank you. We will do one last question here. Okay. Do you think that creating these modern treaties, like the Buffalo Treaty, can help protect other keystone species, such as caribou and salmon in their respective territories?
Very, very much so. Very much so. Because in each territory, on the plains, the buffalo was a keystone species. But elsewhere, hey, it might be the caribou. Over in British Columbia, on the coast, it might be the salmon, see? So in the same way that we depended and had a partnership with the buffalo, hey, the same thing was with the salmon, with the caribou, and so on. So I would say the buffalo and the Buffalo Treaty can act as an example, act as a template for those other species in other indigenous territories. Yes.
Okay, well, I think we're out of time. Thank you so much to Leroy Little Bear for taking the time to speak with us today. And thank you all for tuning in and asking questions. I apologize, there's just too many questions to get through, but I really appreciate everybody taking the time to learn a little bit about sovereignty in Indigenous communities. So Thank you, and I hope you have a great rest of your day.
Yeah, and I want to thank you for allowing me to share thoughts with you.